Supreme Court of the United Kingdom, where today we're hearing an appeal in the case of CPRE, that's Council for the Protection of Rural England, Kent, and Secretary of State for Communities and Local Government. The appeal is concerned with an issue of costs in relation to judicial review proceedings. I'm hearing the appeal with 4 colleagues, whom I will introduce now. First, Lord Hodge.
Good morning.
Lord Lloyd Jones.
Good morning.
Lord Leggett.
Good morning.
And Lord Burrows.
Good morning.
The appellants in the case are represented by Mr. Westaway and Ms. Brabkin-Reiter, and I'll invite now Mr. Westaway to begin his submission.
I'm grateful, my lord. The issue in this case, more specifically, is whether parties additional to the primary public law defendant should generally be entitled to their costs of responding to statutory review or judicial review claims where permission is refused for the claim to proceed. The difference between us is we say, my lord, that consistent with the general principle that was set out in Bolton, a House of Lords decision from 1995, only one set of costs should be awarded. The respondent says that at the permission stage, multiple sets of costs should be awarded, and there's no dispute between the appellant and the respondent that the Bolton principles, which I'll come to, apply at all other stages. We say there's no good reason to exclude its application at the permission stage, and that the courts, and in particular the court below, erred in restricting its application in this case. My lord,
now, Mr. Westaway, if I can interrupt you, we've read the parties' written cases. The cases don't make any reference to our recent decision in the Gourlay case, and I presume that's because it came too late for it to be addressed. But we obviously need you to address it today, and you'll need to identify for us what point of law you say arises in this appeal, as distinct from guidance as to practice.
I intend to address that straight away. Gourlay, my lord, is included in the authorities bundle, but
yes,
correct observation that it wasn't anticipated in the cases. I think our case preceded the decision.
Yeah.
And of course, I think all parties are very conscious that it was a similar constitution that determined Gourlay. So your lordships will not need a great deal of explanation of that case. The case indicated in our reading, my lord, that the Supreme Court should ordinarily be slow to intervene in matters of practice, including costs. It doesn't amount to an injunction that the Supreme Court can or should never intervene. And there is a focus on points of law, but on the reading of it that we take, it's not an exclusive focus. But I want to address the point immediately. Well, Gourlay is in the authorities bundle, page 783 and following. And in the, so I may have given you a wrong reference there. Starts a little bit earlier, 768. So in the bundle 768 and following. And it recognises at paras 32 and following, there are circumstances where the Supreme Court may intervene in appeals on costs. Providing some examples, those 4 cases are ones which have been provided to the court by way of a separate clip. So that's, and the pagination is sequential. So hopefully, my lords all have that.
yes.
We say there's 3 reasons why the Supreme Court should entertain this appeal. First, and this focuses on the point of my Lord Reed, well, cost is, of course, a matter of discretion, the issue here does give rise to an error of law. And to paraphrase, pick up the language of paragraph 43 of Gourlay, that's page 786. The decision awarding costs was vitiated by a failure to exercise the discretion rationally and in accordance with established principles. And in our submission, the established principles in this case are articulated by the House of Lords in Bolton and have been widely applied since. We say that neither the civil procedure rules nor Mount Cook that addresses them, nor the other case law relied upon by the respondent provides a principled reason for departing from those principles at the permission stage. And this, my lord, is a very real case where the lower courts have erred since at least Mount Cook in opining on multiple party costs at the permission stage without reference to and then later proper accord to the principle in Bolton. We also say, my lord, that in this case, and I'll come to it when we look at the judgment below, but there's an inappropriate reliance upon cost principles from private civil law, and there's an important distinction between public and private law. My lord, dealing with, and I don't intend to go through them in any great detail, but dealing with the cases, the 4 cases that are referred to in Gourlay, Paris 32 and following, there's some analogy in my submission with the Hunt and North Somerset case. There, the Court of Appeal was held by the Supreme Court, my lord will remember, to be wrong in principle to treat the local authority as a successful party on the facts of that case. The case is in the further materials, page 1145.
Now that was a question of interpretation of a phrase in the CPR.
It's a question of interpretation as applied to facts. So I appreciate, I mean, in my submission, there's not a absolute bright line distinction between what is a point of law and a point of practice. One can identify on the one side points that are clearly of practice, and in the Gourlay case, Davis, that approach that's taken was recognised by the Supreme Court to be a point more or less of pure practice. When one's looking at what successful party means and how discretion is applied to that, it's a point which raises perhaps a stronger element of principle, and I would say that's analogous to some extent with this case. Of course, it's not the same. And my lord, I think in that case, I simply note that in the judgment of Lord Tolson, so it's page 1145, paras 15 to 16.
Now, Mr. Westaway, we do have we have it actually at page, it begins at page 42. The second bundle is separately paginated.
This is page 47.
Well, I do apologise because my bundle has sequential pagination from the main electronic bundle.
Yeah.
So I'm a bit out there.
Yes.
I'll have to do my best by references to paragraph numbers.
Yeah.
So it's paragraphs 15 and 16. And in particular, at paragraph 16, my lord, Lord Tolson refers to wider public factors to consider and notes the point that we raise in this case. Public law is not about private rights but about public wrongs. And it's important that the principles are got right. So we do say that this case gives rise to an error of law, and obviously in my submissions I develop that. In particular, we draw attention to the error in the case of Mount Cook itself, and perhaps more pertinently, how Mount Cook has been interpreted. Second, my lord, so the second reason why we say the Supreme Court should entertain this appeal is that the appeal is based upon a seminal decision of the House of Lords itself in Bolton. You have that, we'll come to it later, but you have that page 355. It's recognised in the report as a practice note. So in short, my lord, the issue in terms of the principle to be applied has its origins at this level and is appropriate for it to be reviewed again at this level. My lord, on that point, I take it fairly briefly, but again, we say some analogy can be drawn with the other cases. Don't say they're the same, but an analogy. The Cartier International case that my Lord Breed and Hodge will remember well, that concerned costs of the case, but costs of compliance with the court order. It was the website blocking orders case. And like here, one of the main bases for jurisprudential discussion in the case was the decision of the House of Lords, the Norwich Harmicle case. And one could see, I don't know what page it will be, but I don't, paras 9 to 15 of that case. Page 26. It starts on, does it start on page 26? Page 26, para 9. And one can see there the discussion of that case. And it's right that because it's a House of Lords case that it was discussed by the Supreme Court. Similar and second analogy in the XYZ, the Travellers Insurance case. The primary authority relevant to the discussion in that case was again a House of Lords authority, aid and shipping. My lord, of para 3, the para 3 of XYZ, page 52. Lord Briggs says that it's at the bottom of the paragraph, this appeal provides an opportunity to review that developing jurisprudence. And again, at para 30, one can see the approach taken where there is a House of Lords case and uncertainty perhaps caused by the application of that case. That Lord Briggs was prepared halfway through the paragraph, para 30. He says that rather on this occasion, or rather I should say this is an occasion, in more granular detail to consider the principles which ought to apply. So where there is a sort of foundational decision at this level, in my submission, it is appropriate that the Supreme Court consider the issues that arise on the application.
You'll be aware that that case and the others that you've just cited, Hunt and Cartier, were all discussed in Gourlay, and the errors of law which were the basis of the court intervening were identified in each of those cases.
My lord, I say there's an error of law here, but I
Mhm.
say it goes a little further because Bolton comes from this level.
But
And
that's
in my
because
submission, one of the reasons
in Bolton, the House of Lords had to decide the issue of cost because the case had been argued to the House of Lords, and so the question arose before the House of Lords. But in this case, the situation is different because this is an appeal against an award of cost by a lower court. So, you know, we're not compelled to deal with the issue of cost. The question is whether we want to exercise an appellate jurisdiction over the award of costs by a lower court.
And I certainly submit that this court should exercise that jurisdiction. Really, it runs throughout our submissions as to why, and I'll get on to those. But part of that is because Bolton is an authority at this level. I'll come on to Bolton, but entirely accept that the issue was argued on costs in Bolton. But what's significant is that the court took the opportunity to set out the propositions or principles in the way that it did, and that's something that has had significant ramifications as a matter of principle in the public law courts of England and Wales. So I'll come on to that. My lord, the third reason why we'd urge the Supreme Court to entertain this appeal is that we say there's general public importance in the issue that's raised. Permission to appeal, of course, was granted. The case, my lord, concerns the position of an individual claimant in public law, and principles of access to justice and certainty are in play. My lord, I want to emphasise at the outset that while the numbers may seem small, they are significant for individual claimants, whether multiple sets of costs therefore routinely fall to be awarded makes a big difference. For the individual affected by a public law decision, whether there is a risk of, say, £2,500 or £5,000 liability following the opinion of the court on the arguability of the claim, is very significant. And my lord, this is covered. Richard Buxton, the solicitor for the appellant, in the application for permission to appeal, put in some witness statements. The first one was in support of the application, the second one came later. And in the bundle at page 316 to 317, I'll just ask your lordships to have regard to what he says there. Paras 10 to 11. The other point, my lord, that flows from that is certainty. And certainty, of course, is not just in the interests of claimants, but of all parties, including interested parties. And one issue that arises here is that the practice below is very uncertain. We say that is because of the lack of a principled approach, and that's not resolved by the Court of Appeal judgment below in this case. That also, in my submission, does present a distinction to Gourlay, in that in Gourlay, the court was concerned with a well-settled practice from the 2004 case of Davies, Court of Appeal case of Davies. So clearly some of those themes, my lord, will be developed in the submissions that I'll come to now. But that, in brief, is what we say about the application of Gourlay, that it should not prevent this court considering the issues, and that we say that this does raise an issue of law, but even if it doesn't, it's one of sufficient public importance, and given the source of the guidance in Bolton, this court should entertain it. My lords, I'll come on to structure. So I have really 6 topics I want to get through this morning. First of all, some general remarks on the distinct nature of public law cases. Second, Bolton, its context and its significance. Third, why we say there's no principled justification for adopting a different approach at the permission stage. And that will deal with Mount Cook in particular. Fourth, why the decisions below in this case were wrong. Fifth, the outcome in this case. And then, my Lord, in granting permission, the panel invited submissions on practical effect. I think both parties cover that to some extent in our cases in accordance with the expectation. That invitation is at page 147 of the bundle. You also have the witness statements from my instructing solicitor, and I intend to address that point briefly at the close in whatever time may remain for me. My Lord, first, as far as the distinction in public law cases is concerned, it's a critical point that underlies this appeal, and the authorities recognise, particularly in relation to costs, that a different approach should be applied in judicial or statutory review as opposed to ordinary private civil law. One reference, I think, present purposes for that, the Corner House case, and that case starts page 739, but the discussions at para 69, page 763. Para 69 and into 70, but it's really para 69. I mean, it may be an obvious point that public law is different from private law, but it's important because it also has implications, of course, for the costs. We expand on this a lot more in our case. The distinction can be articulated in a number of ways, but perhaps the most important point is the different relationship that the parties have to the court in public law cases, where the question is about the lawfulness of actions of the public authority. And that is invariably the case. It's necessarily the case that there's a public authority at the centre of public law actions. There'll be, I suppose, rare examples like the Smeaton case. But even there's a public authority controlling things in the middle. And the defendant, that public authority defendant, is in a different position to an ordinary party. We refer to Huddleston. Huddleston is a pre-CPR case, but it's a case that's very much current in terms of the approach that it presents. The reference there is page 378. And it's the discussion that starts at the top of that page. But draw attention in particular, my lords, to 945C on page 378. The development of administrative laws created a new relationship between the courts and those who derive their authority from public law. Public authorities are under a duty of candour, no dispute about that. And what, my lord, we call or may call two-way cost shifting between parties makes sense in that context, between a claimant and a defendant. Other parties are in public law proceedings in a different position. And two key points here: they're not alleged, except maybe in exceptional cases, to have committed any wrong. And at the determination of a claim, they are first generally not at risk of adverse cost awards, so they won't be charged for unsuccessful arguments, nor are they entitled to recover them. That latter point, of course, applying Bolton. And the approach that's advocated for by the respondent in this case would allow generally for sort of 3 or more way cost shifting, which we say as a matter of principle is not justified as a general approach. This underlying point about public law may be characterised, my lord, as a balance. And it links, of course, to other principles we've touched on already, so and we set them out in our case. I'll just mention them: access to justice, the ability of claimants to, willingness of claimants to bring claims where there's been a public authority wrong, and certainty. My lord, I want to come on to Bolton. This is the second sort of broad heading. Before I get to the case itself, there's 3 important points of context to Bolton that we say are key to sort of understanding where the case fits. The first point, my lord, is that Bolton reflects a general public law position, and we set out.
Mr. Westaway.
Yes.
Sorry to interrupt you, but you were looking down. Could I just ask a question before you move on to your second range of submissions? Is there any equivalent in private law proceedings of interested parties, do you think?
I think there's not. An interested party would be an intervener in private law language, an intervener in the case because it has an interest in the case of some kind. And the principles as far as interveners are concerned with costs, we don't set them out here, but I understand that they are generally that they would not get their costs. Of course, the discretion is always there.
So you see the interested party as a unique scenario relevant to public law cases?
Yes, the distinction is that the defendant is the wrongdoer. It will not be the interested party who's at the focus of a public law claim, and that's the important distinction. The other one, which we draw attention to, is that the defendant has some quite strong duties toward the court. It's not like an ordinary litigant. It can't hide things away and play tactics. It has to be candid, open, and upfront. So coming on to Bolton, 3 points of context. First,
Sorry again.
I must get better at checking my screen.
I just wanted to follow up Lord Burrow's question by asking Mr. Westaway, you present the issue on this appeal as one of how many sets of costs you get. Might seem to be one of practice. Is there perhaps also a narrower issue which you might at least more readily characterize as one of principle, which is whether when in public law proceedings a decision of a public body is challenged, a private developer to be entitled to its costs of defending its own private interests as an interested party.
As a matter of general principle, I would say that is a matter of principle, and we say, of course, that they should not generally be entitled to that. The public authority will be defending the lawfulness of its decision. Now, of course, there will be cases where, for reasons that are not completely uncommon, it will be appropriate to award costs to a developer or another interested party for some reason, but generally it will not be. My Lord, in terms of the points of context for Bolton, so the first point of context is that Bolton didn't come out the blue. It reflects the position in public law generally. We cover this in our case and draw attention to another practice note from 50 or so more years ago, from 1954, the American Express case. You've got that in the bundle at 367, the reference 367 and following. Very short, and the key parts of that, my Lord, are the opinion of the court as to what should happen in future, about halfway down the Lord Chief Justice's judgment, and then about 8-9 lines up from the bottom, it is not necessary for the parties to appear merely because they are served. Goes on to say, as a general rule, there should only be effectively one set of costs. So it's setting out, and this is reflected in plenty of other case law we refer to, some of it in our case, that an entitlement to appear, an entitlement to participate, an interest in a claim does not equate to an entitlement to costs in public law cases. The second point, my lords, of context for Bolton. Bolton was addressing the divergence from that practice in planning challenges. And that can be most clearly seen from a case that's referred to in Bolton, Wychehaven. Wychehaven's in the bundle at 447. This was a section 288 challenge, so planning challenge. In the High Court, the developer was awarded its costs, but the Secretary of State was withheld. And as the challenge was to the Secretary of State's decision, the Secretary of State appealed, arguing that he should get his costs. My lords, the Court of Appeal was unable to overturn the award of costs in favour of the developer, because there was no cross appeal. Presumably the developer didn't participate at this level. But one could see the problem that the court grappled with on 449, towards the bottom of the page. A discussion of what happened in the case. And what was argued is there should be this reliance upon what's called a normal practice. Interested parties should get their costs. And Lord Justice Leggett, my lords, criticised that reliance upon normal or common practice. He did so because he said principle should come into play over practice. And it's really over the page on 450 of the main points I rely upon. Just to enumerate them. First of all, my lords will see that Lord Justice Leggett saying that while a developer is entitled to be represented, so again, entitlement to be represented, it does not follow that a claimant should be called upon to bear more than one set of costs. So standing doesn't translate into costs. Secondly, the focus on the Secretary of State's decision, so consistently really with all public law challenges, Secretary of State should have got its costs because it was the Secretary of State's decision that was being challenged. And my lords, on that point, that's endorsing the submission. If my lords will turn back a page to 449, that's endorsing the submission made by Mr. Drabble on behalf of the Secretary of State. Top of that page, about 5 lines down. Mr. Drabble submits everybody would know the Secretary of State would always appear and defend his decision in relation to an appeal. It's always the case that the Secretary of State will consider a properly brought challenge, might concede it, or otherwise defend it. Going back to 450, my lords, I think this is one particular part of Lord Justice Leggett's judgment that's quoted in Bolton. About 2/3 of the way down, indicates, as far as the position of the developer is concerned, not directly an issue, as I explained, but if the developer had not been awarded any part of his costs, he might not have been able to complain. And then goes on, I suppose, to follow that up, to say, in my judgment, this is the last paragraph, in my judgment, in circumstances such as these, the court should be disposed to make only one order for costs. So that was the practice as it stood going into Bolton. Third point of context, my lords, for Bolton is the procedural context. I'll take this quite briefly. Bolton was not judicial review. It was a claim brought under section 288 of the Town and Country Planning Act under what was RSC Order 94. And under Order 94, there would have been service on the Secretary of State and the developer. Just for your notes, you've got that order in the materials. It's Rule 2.2d, page 894 to 5. And there would have been requirement for, if there was evidence in opposition, any evidence to be filed in opposition. That's Rule 3.3, page 895, same page. But while there was no permission stage, there was service, and the Secretary of State and developer were served and entitled to respond to the claim. Indeed, they would have had to respond had they wished to oppose the claim, and there's no particular reason why they would have known each other's arguments in advance. My lords, I want to come on to Bolton. It was in that context that the House of Lords considered it appropriate to articulate the general propositions in Bolton, and specifically to disapprove of the practice of the lower courts awarding 2 sets of costs in planning appeals. Bolton, my lords, was a a Section 288 challenge as well. It was slightly unusual. It was a consortium of 8 authorities challenging the Trafford Centre project, following a very long inquiry process. I think lasted some 7 years. A bit of a cause célèbre, and one could see why the courts might have felt in that case the need to set out propositions. The propositions, my lord, are on page 357. And in Lord Lloyd Berwick's speech, it says, what is the proper approach? It's internal 1178 at F. And there's 4 propositions that go over the page. I don't think I need to go through these in depth, but I do want to make some observations about them briefly. The first point reflects the discussion we just had. The focus is on the Secretary of State entitled to his costs. I say that follows because it's the Secretary of State's decision that's under challenge, and that reflects really most public law. The second point perhaps is critical. The developer will not normally be entitled to his costs unless he can show that there was likely to be a separate issue on which he was entitled to be heard, or unless he has an interest which requires separate representation. And in my submission, what Lord Lloyd of Berwick here is contemplating is a developer who's served, as he would have been, with a claim under Section 288. He looks at the claim and can see, well, is there likely to be a separate issue, or do I have a separate interest? It doesn't depend upon understanding at that point what the position of the Secretary of State is. It's a simple question of, does this claim, this public law claim, give rise to matters that are likely to require me to set out things that, to cover a separate issue? And most of the time, my lord, that question would be answered in the negative. Most of the time, public authority decisions that are under challenge may be failure to have regard to material considerations, breach of legitimate expectation caused by actions of that authority, etc., won't give rise to separate issues that need to be addressed by interested parties. The third proposition, my lord, observes that a second set of costs is more likely to be awarded at first instance than in the Court of Appeal or House of Lords. And in my submission, that confirms that the House of Lords, and Lord Lloyd and Berwick in particular, considered this approach to apply generally, not just to the appellate courts. And of course, it might be that even issues where there's some discrete interest get clarified later on in the appellate process. It's a perfectly sensible observation. That's also consistent, my lords, with one, the result in Bolton, but also the fact that the practice which Bolton was concerned to correct was one that had arisen at first instance. And then over the page, my lords, 358, proposition 4. The point about a third set of costs being rarely being justified. In a way, I think that's an observation that by the time one's had, if there were separate issues, once had those articulated, there's very rarely going to be any more to articulate. So we say, my lord, that Bolton 1 reflects the position elsewhere in public law, and 2 is intended to be of general application. My last point on Bolton is its reception, and I think it's correct to observe, perhaps unsurprisingly, that Bolton has been very widely applied in judicial review and statutory review cases at all levels. That's both pre-CPR in 2001 and post-CPR. It is, as a set of established propositions, very bedded in. In our case, models, we give various examples, and some of those examples are replicated in the bundle before you. I want to pick out just two to show the established application of Bolton and how we say it should and does apply. The first case is pre-CPR, second case is post-CPR. Both involve football clubs. So the first case models the challenge of Lady Berkeley to the development for the proposals of Fulham Football Club, and there's a separate cost judgment that was promulgated by the Court of Appeal. You have that, page 592. So it's Lord Justice Norse. Part of this, of course, is a discussion about Secretary of State costs. At page 597, he comes on to consider the application for the cost of the club. And I draw your Lordship's attention to how he describes Bolton, I say correctly, at the top of page 597, principles of discretion authoritatively stated. And if your Lordships turn over to, he sets out Mr. Hicks's argument for the club and then addresses it, page 598 to 599. And rather than me read that, I'll just invite your Lordship to read from putting that third point on one side, just to the very top of the next page. My Lords, the second case is a case called Bedford against Islington. Islington is the home of Arsenal Football Club, and this was the case that concerned their stadium relocation proposal and a challenge to it. Of course, the decision there was Islington's, not the football club. And this is one of very many post-CPR decisions to rely upon Bolton. You have it, my Lords, in the bundle at 721.
What's the point of citing these authorities to us? What are we meant to take from them?
They're examples, my Lord. I can point, perhaps the most convenient way of answering it is to get through this one, point, my Lord, to the relevant part of it, and then answer the question.
I'm getting rather fed up being just read one case after another without a proposition of law emerging from them. Traditionally, you tell the court what your proposition is, and then you use an authority to vouch it.
Yeah, my Lord, there's 2 points here. The first is an illustration of what we show further in our case, that Bolton is very bedded in. It applies generally. The second is perhaps more important. It's how Bolton applies. And my learned friends for the respondent note in their case that interested parties can be in a very good position to respond to claims. They note that interested parties can be of assistance. But applying Bolton properly, that's not enough.
What you have to face up to is that the Court of Appeal have said that under the current CPR, which was not something the House of Lords, of course, was concerned with, the matter should be viewed on a case-by-case basis. On what basis is this court meant to interfere with that?
Well, and in terms of the proportionality approach, I say that gets Bolton wrong, and I'll come to that. But what Bolton is doing, and it's to misunderstand Bolton, to see it as something that should be addressed on a case-by-case basis. Bolton is more fundamental than that.
They're not dealing with the same issue that was before the House of Lords in Bolton. They're simply dealing with how you deal with costs arising from acknowledgements of service, which the CPR requires to be filed. And they're saying you deal with it on a case-by-case basis rather than there being a rule.
My lord, the Bolton arose in the circumstances it did. In my submission, the CPR does not.
Until very recently, it was well understood that this court did not take appeals on costs, except and indeed the House of Lords didn't take appeals on costs unless in exceptional cases. And Bolton wasn't an appeal on costs. It was the court, the House of Lords, dealing with the costs of an appeal which had been heard by them. We're being asked here to ourselves give guidance to the Court of Appeal on a question of pure practice, are we not?
My lord, my speech is not as simple as that. The question is, what is the status of Bolton at the permission stage? And as we develop in our case,
Bolton says nothing about how you deal with costs arising from compliance with a CPR which did not exist when Bolton was decided.
the procedure was different when Bolton was decided.
And that's the whole point.
But there's no principled reason in my submission why the procedure should disapply or affect the application of Bolton. Many of these cases we rely upon are, of course, post-CPR cases, and Bolton still applies. There's no dispute about that, and that it should apply. What we have is a departure from Bolton at the permission stage, and the critical question is whether that departure at the permission stage is justified. So I refer to these cases partly to show the widespread application of Bolton, partly to show that even where interested parties have been said to bring something to the case, that's not enough. And cutting to the chase on the Arsenal Football Stadium case, my lord, the reference is para 297 on page 730. Perhaps don't need to go there right now. So Bolton is bedded in and applies generally, even post CPR at the substantive stage. In my submission, this brings me on to the third main heading for my submissions today. A different approach should not apply at the permission stage. Simply, my lords, because it's a permission stage is not, in my submission, a good reason for drawing that distinction, and it's possible to go further, if anything, given that it's a permission stage where the threshold is only that the claim is arguable, there's less call for the involvement of interested parties. And I draw attention to what was said by Mr. Justice Mayles, as he then was, in the Tewkesbury Borough Council case. It's para 10 of that judgment, page 842. 842. An argument had been made before him that because the claim was weak, there was more reason for interested parties to get their costs. He says, on the contrary, if the case was so weak it was obviously bound to fail, it might be said there's less justification for developers to incur substantial legal costs over and above those incurred by the Secretary of State. The reason, my lord, why it's said that the permission stage falls to be distinguished turns upon what's said to be the import of particular rules in the CPR. And that's really rules 54.8 and 54.9, and we find them replicated in Practice Direction 8C. You've got those rules in the bundle. I suspect your lordship's familiar with the terms of them. 54.8 and 9 of page 470 and following, and they're replicated at 457 in PD8C. But we can see the language at page 470. .8 covers acknowledgements of service, and 54.9 links to it. It's where there's a failure to acknowledgement of service. It sets out, I think, as the critical points relied upon in the case law, what in Mount Cook and in the case below, the sanction. Well, I've got 5 submissions to make on this. The overarching point is that we say that nothing in the CPR can sensibly be read to displace a Bolton approach, and the authorities are wrong as a matter of legal principle so to suggest. First point, the CPR itself says nothing about costs at the permission stage. The only reference, and your lordships will have seen this, to costs is Practice Direction 54A, paras 8.5 to 8.6. That's about cost of oral renewal hearings. So the starting point must be that the principles are left to what is established. The matter is left to established principles. Secondly, my lord, the notion of a positive obligation to acknowledge service in para 54.8 should not be overstated. Even for a defendant, whether to acknowledge service when a claim is brought is a choice. It's not required if those parties wish to participate in the substantive judicial review claim. And we give various references to that. The Administrative Court Guidance, for example, it's bundle page 506, notes that it might be wise for parties to respond, but it's not mandatory. The Smith on judicial review, para 16098, page 1077, notes that parties are entitled but not obliged to respond. And there's various other references. It's clear that's the case when 54.8, 54.9 and 54.14 are read together. And it's deliberate, my lords, and it's a deliberate distinction between public law, judicial review, and private cases. The rationale for it may be seen in the Bowman report, para 25. Page 552, para 25 on page 552. And Bowman, in recommending that there should be no bar, there should be this license given in public law proceedings, notes the distinction. So really in my submission, and this is the third point, really it all hangs upon the sanction in CPR 54.9 in terms of the analysis. And in my submission, that's simply not sufficient to justify the distinction from Bolton. There's two parts to it. 54.91 page 471, my lords. As far as participation is concerned, the opportunity to file detailed grounds remains. And as we note in our case, this is preferential treatment from ordinary civil law cases. There's no bar if you don't file an acknowledgement of service. It may be wise, may be sensible to do so, but it doesn't prohibit you from participating in the claim in the way that it would with private law claims. As far as costs are concerned, this is 54.92. 54.92 does mention costs and says where that person takes part in the hearing of the judicial review, court may take the failure to file an acknowledgement of service into account when deciding what order to make about cost. Now, my lord, it's no part of the appellant's case that a defendant should not generally get its costs at the commission stage. We accept that's consistent with Bolton and is consistent with 54.92. It makes sense. But in ordinary cases, the potential cost sanction in 54.92 will be of no consequence for interested parties who will be neither liable for costs to or nor able to claim costs from the claimant at the conclusion of the substantive hearing. So this is consistency and balance. It makes no sense to see this provision, 54.92, in isolation from that substantive stage. And the courts, my lord, in relying in particular on 54.92, to draw that distinction, and they err because they don't consider Bolton at the substantive stage and how it does and should apply. My learned friends rely upon a case called Ademelui, which is in the bundle at 714. That case in my submission doesn't assist the respondent. It was a case where the Secretary of State was late with its acknowledgement of service and didn't file detailed grounds. It was an immigration case. But even then, my lords, the judge in the case granted permission for the Secretary of State to participate in the hearing. So in my submission, it rather illustrates the distinction between judicial review and private law cases rather than what I think the respondent relies upon it for. And I note also, my lords, this is it's in the judgment, I think, of Miss Justice Ford, Michael Fordham QC as he was. Para 26, page 718. That the judge considers the possibility of summary judgment or judgment in default, given the lack of participation or inadequate participation from the Secretary of State. But notes, it's about halfway down the paragraph, the judicial review court is the guardian of the public interest in public law cases. So the case not only doesn't help the respondent in my submission, but it also demonstrates why the language of strikeout summary judgment from private law is simply not apt when one's looking at public law cases. And also my fourth submission on this heading might take a little longer, and I note it's 11:43, so now might be a moment for a 5-minute break.
Very well, thank you. We'll adjourn then for 5 minutes. Yes, Mr. Westaway.
Thank you. I was just about to turn to the fourth point on the permission stage, and this is critical because this is the wrong turning that we say has been taken by the courts. So we say that the case law that's relied upon, was relied upon in this case, to support a general principle that interested parties should get their costs at the permission stage is in error. I can take, I think, Leach fairly briefly. You have Leach, which is a High Court case of Mr. Justice Collins in the bundle at 359. And on 360, my lords will see that the party represented by Mr. Corner was the Commissioner for Administration. The case only concerned that public law defendant's costs. And we can see, I think, Mr. Justice Collins's comments, para 14, 362 to 363. Must be seen in that context. Reference to fairness. But the judge did not have to engage with the principle or the fairness of awarding multiple sets of costs. Simply doesn't arise. What happens then is we have the case of Mount Cook. Mount Cook, at this point, relies on Leach. Mount Cook's in the bundle, page 410 and following. And again, my lords, in Mount Cook's, no issue as to multiple costs. The only costs an issue are Westminster City Councils. There's no cause for the Court of Appeal to consider or discuss Bolton principles. The issue on costs that arose on the procedural background of Mount Cook set out at para 18.4, page 417. And your lordships will see 2 points about that issue. It concerns defendant, and actually the focus is on the oral application for permission, not the acknowledgement of service stage. That issue is then discussed in the judgment of Lord Justice Auld, page 428, paragraph 47 and following. and that includes reference to leach. See that in particular, page 430. And then one turns to the submissions, the arguments that were in play in Mount Cook case. Para 59, 433 is Mr. Steele first. I draw attention to the Westminster City Council arguments, Mr. Corner's, para 63 and following, page 434. And I do that because in my submission, it shows, understandably, the focus is on fairness in the context of a defendant's public law defendant. One can see that in particular, para 64. General principle is unfair, defendant should have to bear the cost. This is the bottom of the paragraph. The waste of public funds. And then, my lord, Mr. Corner draws attention to and important support from the pre-action protocol for judicial review, which requires the proposed defendant to respond. And I note, we cover this in our case para 76. But there's no equivalent obligation on interested parties to respond. The pre-action protocol correspondence. And in that sense, it reflects the symmetry across the whole framework. We have pre-action stage, no obligation on interested parties to respond. Substantive stage, interested parties generally won't get their costs. Why, in my submission, in the middle, when one's looking at the permission stage, should a different approach apply? And in my submission, there's no principled reason why it should. The conclusions, in order para 67 and following, they need to be understood in the context that multiple party costs was not an issue that was before the Court of Appeal. And had they been an issue, in my submission, the court would have to have addressed Bolton. In fact, and the critical paragraphs, para 76, page 437, and really for our purposes, it's just the first proposition. The remaining ones go to the point about oral hearings, where Lord Justice Auld says, at the bottom of page 437, the effect of leach, certainly in the case to which the pre-action protocol applies, and where a defendant or other interested party has complied with it, is that a successful defendant or other party at the permission stage who's filed an acknowledgement service should generally recover the cost of doing so. And that's the nub of the reasoning that's been relied upon to create this general approach that interested parties should get their costs at the permission stage, I say in clear contradistinction to Bolton and the substantive stage. There's two ways of viewing that reasoning, and both lead to the same conclusion. First of all, my lord, it's obiter insofar as it relates to interested party costs, but it does purport to cover that matter. If that's the case, we say it's wrong. It's per incuriam in the cleanest sense of the expression, in that reference was not made to an earlier authoritative judgment that would have been relevant, i.e. Bolton. The second way of viewing it is that Mount Cook says nothing about multiple sets of costs didn't arise. And there's no reason to read in necessary reference in Mount Cook to multiple sets of costs. If that was the case, then there was no need for Mount Cook specifically to consider Bolton. But if that's the case, my lord, it's been wrongly relied upon subsequently. It's that sort of short sentence there, or other party, that has led to this whole debate. My lords, we're not a lone voice here. Doubts about the correctness of Mount Cook on the point about multiple parties are widely expressed. And I want to draw attention to three. There are others. First of all, Supperston, Gowdy and Walker on Judicial Review, the 6th edition. We provide in the bundle page 1073. The extract is para 19.85, and perhaps I can just ask your lordships to read that. So that is clearly recognising the issue of principle, the tension between Bolton, the well-established general rule, and what's said to be a Mount Cook, but going further and doubting whether Mount Cook can really be taken that far. And that is, in a nutshell, what we say is the error of law, summarised there at para 19.85. The uncertainty, the tension, if you like, is also noted in Halsbury's Laws, 61A, 2018 edition. I've got that page 997. So it's para or section 86, costs at the permission stage. And draw attention to two parts of it, talking about cost when permission is refused. Footnote 5 notes Mount Cook was obiter, I think reflecting something. It's also in the White Book on that point. But over the page 998, footnote 10 goes further. Because footnote 10 does something similarly to with Supperston and Gowdy that Mount Cook simply did not do, which is to point to Bolton and its continuing relevance and the inherent inconsistency of multiple costs at the permission stage in Mount Cook and Bolton. So footnote 10, again, I don't want to read it out, but it's the bottom of it. It's the last couple of, it's the penultimate sentence.
Well, I wonder, you haven't, to some extent, you're attacking a bit of a straw man. The Court of Appeal in the present case did consider the relevance of Bolton. It made it clear that the Bolton principles remain relevant in considering whether costs should actually be awarded in a specific case.
The
It's,
in the Court of Appeal relegates Bolton to a proportionality consideration rather than what in my submission it should be, which is a principled consideration. The Court of Appeal in effect relegates Bolton to I do want to address separately, not at length, but I want to address separately how the Court of Appeal dismisses but then adds back in Bolton, and how that doesn't work to deal with the principle in Bolton. So I do want to come to that. I highly appreciate that's important. If I can just finish on the criticisms of Bolton, the last reference is an article from Judicial Review in 2014, Commission in Interested Parties. And I'll give you lots of references rather than go through it all. Article starts on 1079. Para 2, Alistair Mills, who's the author, identifies tension in the law, Para 2 on 1079 itself. Paras 20 to 22 on page 1082. Note that tension. Again, I think rather than go through them all now, I'll just point your logic to them. And then para 32, in the conclusions, notes weighty arguments that interested parties should not be entitled to the costs of submissions on the papers, where defendants also continued with the claim. And this criticism is not about a proportionality assessment. It's about a question of principle as to whether interested parties should generally be entitled. And that was the question of principle that's set out in Bolton. My last point under this heading, I can take, I think, quite shortly. My learned friends rely upon various subsequent cases citing Bolton, so before the Court of Appeal decision in this case, particularly Luton Borough Council, and the Court of Appeal, of course, relied upon the Luton Borough Council case as well. What we say about that's as per our case, and I think it's a fair observation that that case simply relied upon Mount Cook for the proposition that multiple sets of costs may be awarded. There's no detailed discussion of it, certainly not the kind of detailed discussion that this case has been able to give rise to. I appreciate I need to address the Court of Appeal's reasoning in this case, but I don't say that in my submission, the respondent's case isn't much helped by pointing to Luton Borough Council, or indeed some of the other authorities, and they're not all consistent on this, where Mount Cook has been treated as supporting interested party costs. Overall, what we say, Mount Cook is a practice that may be being followed, but the principle has not been questioned. And just as, my lords, the House of Lords in Bolton took the opportunity to confirm the application of principle over practice, so the Supreme Court should do in this case. Well, I want to come to my fourth heading, why the decisions in this case were wrong, and taking them in chronological order. The original cost order that's been challenged here is of Mrs. Justice Lang. It's in the bundle, page 144. Doesn't deal with the point, it simply awards the multiple party costs. One assumes on the basis that those parties are entitled to those costs. There was then a series of representations on that, and that order was upheld by Coroner Judge Evans Gordon, 142, the bundle. At 142, paragraph 1, I think this is set out in the statement of facts and issues, but it's clear that the judge is applying what she considers to be the principle set out in Leach and Mount Cook as a general rule. Defendants and interested parties should normally have their costs. As a general rule, multiple costs should follow. It goes on at the bottom of that to say the principle holds good in such cases. So this case is an illustration of the problem that arises from Mount Cook. It's relied upon as authority for that general rule, which, as I've set out in my submission, is wrong. It's in error. She does go on to reference Bolton, that says that they're distinct and doesn't address the tension. So I say that Mrs. Justice Lang and Coroner Judge Evans Gordon erred by wrongly relying upon Mount Cook as authority for multiple costs at the commission stage. And wrongly failing to recognise the significance of Bolton at that stage. The Court of Appeal judgment is at 121 and following. I mean, much of this repeats the same points. We say that that Lord Justice Coulson erred in principle at para 8. Where he took a private law approach to the public law claim. And one can see clearly what he's doing at para 8, this is page 125. Ordinarily, claimant who wishes himself proceedings on other parties and whose claim is struck out in an early stage will prima facie be liable for the other parties' reasonable and proportionate costs. Issue is, should a different approach apply? There's no. And that approach underlies the conclusion that he comes to, and I entirely appreciate he does refer to Bolton. But in my submission, what Lord Justice Coulson fails to do is to recognise why Bolton matters and why really the principal basis of Bolton. So that really, the reasoning then follows at paras 15 and 17. Lord Justice Coulson, in my submission, wrongly relies upon Mount Cook as setting out general guidance on multiple costs, not just defendant costs, and without questioning the error that was taken in Mount Cook's. And perhaps in fairness, that error had been baked in a little at that stage, but certainly by no means reflected consistent practice. And then at para 21, Lord Justice Coulson addresses the civil procedure rules. and again relies upon Mount Cook. And in my submission, he erred by following Mount Cook and considering that those rules provided a principled justification for departing from a Bolton approach. He then goes on to consider the authorities. And my Lord Reid notes of the point that he does incorporate Bolton into his reasoning of para 23 and following. So that's obviously something that I need to address. But as we say in our case, my Lord, proportionality is no answer to the point of principle. And there's, in my submission, a number of reasons for this. As a general point, it would be odd if proportionality that was introduced to control the incidence of costs were to put claimants in a worse position than pre-CPR. More specifically, proportionality, which is set out at CPR 44.3 and 44.4, and you've got those in the bundle, page 462 and 463. Proportionality goes to the basis of assessment, 44.3, and 44.4, the factors to be taken into account in deciding the amount of cost. Whereas the issue that arises here on the back of Bolton is whether or not the costs in principle should be recoverable. And my Lord, one can see the inadequacy of proportionality in addressing that point of principle and why therefore it doesn't provide an answer to the criticism and the tensions that arise in para 25 of the judgment under appeal. And it's at the bottom of that page, it's page 131. Where Lord Justice Coulson says that where a judge has two sets of summary grounds, he or she will consider the utility of each and the extent to which one defendant should have anticipated the point raised by another, so as to make a proportionate costs order. It depends upon that subsequent considerations, the first point, and it depends upon a starting point that those costs are recoverable. And in practice, we've got some examples in the bundle. Of course, these are only examples, and the ones that happen to be have come to the attention of one solicitor's firm. But we've got examples of post-CPRE proportionality assessments that, in my submission, show the inadequacy of proportionality to address the point principle. The first one is Berry. And that's the consideration of Sir Ross Cranston, September 2019, bundle page 321. And it's under costs. One can see what's being done there, and it's a quantum point, not a principle. A reasonable and proportionate amount for interested party. This is the second half of the para under costs. Seems no more than the defendant, hence the amount below, total amount 7,000. And secondly, you've got a case called Bertoncini, December 2019, decision of Mr. Justice Waxman, and it's page 329. paragraph 4, similar point. My Lords, I want to address briefly a separate criticism we have of judgment, and that's para 53 of the judgment. This is in our case at paras 99 to 106.
Do you have permission to appeal on this?
My Lords, the respondent argues that we do not.
Yeah.
It was a matter that was raised within our permission to appeal submissions directly, and it may be worth just going straight to that. Page 28.
Well, before we get to 28, what about page 21? Paragraph 16.
Well, we're not pursuing ground 3. That I'm absolutely clear about that. We're not doing that.
All right.
The reason why we raise this point is because it's connected to the main point under appeal, and we say it's an error in the Court of Appeal's judgment. We therefore say
paragraph 16, you say that issues as to quantum and the Aarhus cap discussed at 41 to 57 are not pursued now. And you say one issue remains, paragraph 17, which is the issue you've just addressed us on. So you better tell us what the new issue is that you say you have permission to appeal on.
My Lords, in terms, I'll address the court briefly. You have our written submissions on it.
Well, you won't address us at all unless you have permission to appeal on it. Do you have permission to appeal?
On ground 3, Mel, we don't have permission, nor did we ever pursue permission to appeal. The reason that we raised this issue within the permission to appeal application is because it's a paragraph of reasoning in the judgment, which we say is wrong in principle. And the Supreme Court, when reviewing the judgment, should take the opportunity to consider. I entirely appreciate it's a matter for the Supreme Court whether you take up that invitation.
Well, the respondents urge us not to because it falls outside the scope of the appeal. And if that's right, that seems to be the end of it.
Yeah. Well, the respondents' case, it's in their case, para 88.4, is that substantial expense should not be expected at the permission stage, which is quite the opposite of what is suggested by Lord Justice Coulson at para 53. My Lord, I don't want to labour it, but I do extend the invitation to this court to correct what I say is the error of principle that's found in para 53, and highly accept it's not a ground of appeal on the quantum points. We're not pursuing that.
Well, I think having said that, there's probably no more to be said, is there?
My Lord, it's in writing. I think the only point that I would add.
Well, I think you seem to concede that it's outside your grounds of appeal. So if that's right, then I don't think we should hear you any further on this.
My Lord, I'll just make one point on para 53. As I said,
why you don't seem to be listening to what I'm saying.
my lord, and the point links back to our ground one. That's the one point I will make on it.
All right.
Otherwise, I propose to leave the invitation as we have it in writing. I don't withdraw it, but I leave it there. The one point, my lord, is now paragraph 53 in the judgment is on page 138. We set out our criticisms of it within the case, but one can see in my submission, when one looks at the reasoning here, a private law approach being taken for the incidence of costs in a public law case, and that links directly to what we say was one of the errors that underlies this Court of Appeal judgment. And between B and C on that page, one could see that in particular by the reference to defendants or interested parties, it being no good keeping any particular points up their sleeve for a later date. They need to deploy their arguments at the outset. Otherwise, beyond that, my lord, I'll leave it. I won't trouble the court further with that, but we do set out our case in writing, and clearly it's open to this court to comment on that paragraph. I'll leave the invitation there. My lord, that brings me on to the fifth topic, which is what should be the outcome in this case. We cover this in our case at para 108 and following. We say there's nothing unusual about this case. It was a challenge under section 113 of the Planning and Compulsory Purchase Act to a local plan. Challenge was focused on a particular allocation. My lord, in the statement of facts and issues, para 30, it's page 37 of the materials, it explains what's the one oddity perhaps of this case. Para 3.8. And you'll see the appellant's intention was to serve the claim on council in Rocks Hill, but on lodging the claim, they're advised by the Administrative Court Office that the respondent should be named as first defendant. The respondent does need to be served, but it was that oddity of the nomenclature that was used, and I'll come to that. There's 4 points I want to emphasize about the responses of the three parties to this claim. The first point is that all agreed that the Secretary of State should be named as interested party or second defendant, and that Maidstone Borough Council, the planning authority whose plan it was that was under challenge, primary defendant. And one can see that from the submissions that are made on it and the head notes that are used in the summary grounds of resistance provided by the three parties. The page references for your notes 182 to 3, para 7, 200 to 201, para 1, and the head note at 224. Second, there's clear references within the various summary grounds to cooperation between the parties in responding. They refer to each other's responses. And again, I'll give references. Para 19 on 187, so 187 and para 19, it's the Secretary of State. Para 10 on page 202. planning authority, and pages 237 to 238, paras 50 and 58. Third, there's no substantive difference between the positions that are taken by the three parties in response to the claim. Maybe the planning authority is a little longer, but that's unsurprising given that the challenge was a failure of assessment, point about objectively assessed need, an argument that the authority had breached its duty to cooperate, and an alleged failure to have regard to material considerations. So standard public law challenges and no real difference between the parties' responses to it. Fourth and lastly, just on these responses, it's interesting to note in terms of their expectations that both the local planning authority and Roxhill refer to and place reliance upon Bolton as applying. The references to that, page 253 to 4, para 6, page 256, para 5. This was a case, my lords, where all the points that needed to be said in rebuttal of the claim were done by the local planning authority. It was the local planning authority whose decision it was to adopt the plan. And it's that party, in my submission, following the principled approach in Bolton, that should have been awarded costs. The distinction is what we call in our case the unfortunate mix-up about the nomenclature, naming of the respondent as the first defendant. We accept on that basis the appellant did not initially object to paying the respondent's costs. But the final position on the cost submissions is recorded at para 7 of the appellant's costs reply. That's page 259 of the bundle. And perhaps rather tersely, but the point that's made at para 7 259, it's about 5 lines down, leaving quantum to one side. C has no concerns which D should get costs, but the two sets of costs should not be awarded, which D being either planning authority or the Secretary of State, present respondent. So what should the outcome be? We say that given the error of principle, we say is shown in this case, it's for the Supreme Court to exercise its discretion afresh on costs. And given the lack of separate interests and separate issues, in principle, subject to one point, that discretion should be exercised so that only one set of costs be awarded and that go to the local planning authority. And that matter is academic because the local planning authority has already been paid its costs. The one caveat to that is we entirely acknowledge that there was this mix-up about first defendant. And we note, my lords, what was said about that by Her Honour Judge Evans Gordon in her decision at para 4, page 142, over onto page 143. So in my submission, costs should be resolved in accordance with what, albeit in hindsight, is the correct position in principle. That's cost should go to Maidstone. But clearly it's a matter for, assuming we're right on the other points, the matter for the discretion of the Supreme Court, whether it considers that the point at para 4 might justify retaining the award of costs for the Secretary of State in this case. Clearly, it's not the amount of costs that has brought this party to this forum, or indeed that brought this party to the Court of Appeal. This case is about the principle as it applies more generally, not this specific cost. As far as Rocks Hill's costs, that's the interested parties' costs, they were always objected to, and the position we say under Bolton is clear. That party in these circumstances should not have got its costs. So, my Lord, that leaves me only with the outstanding submissions that I have on practical effect that do feed into the importance of the issue, but are points about practical effects. And I think I propose to take them pretty quickly. I've got 4 points to emphasise. My Lord, you'll have seen Mr. Buxton's witness statements. I won't repeat those. So the first point is that the current state of the authorities promotes inconsistency and uncertainty in practice. My Lord, I've drawn attention to some post-Court of Appeal decision cases where a proportionality approach was taken but costs awarded. There are others where costs weren't awarded. Just as before the Court of Appeal's decision, there is no certainty on the back of the Court of Appeal's decision as to what the position would be, and this is problematic. The outcome means it's impossible to advise claimants as to what the position should be. Second, the current situation acts as a deterrent on claims being brought. And of course, that then is a problem for access to justice because claims aren't brought, public law errors potentially stand. Briefly, the Aarhus costs regime, which is referred to by the respondent, is no answer to this point. It's entirely separate, really. Most cases aren't covered by Aarhus in any event, and costs capping orders are only available when permission is granted. You've got section 88.3 of the Criminal Justice Courts Act at page 912. Moreover, even where a case is covered by the Aarhus costs rules, an interested party might argue that either the case is not an Aarhus claim or that the caps should be varied to accommodate costs. And Mr. Buxton gives examples of cases covering both of these situations. For Forbes, the defendant didn't contest that the case was an Aarhus claim. The interested party did. The court agreed. Cost protection fell away. And Burton Cheney, where on the interested party's argument, caps were raised from 5,000 to 20,000. Third point, my Lord, is that this issue, and perhaps those cases are a demonstration of it, puts a greater burden on the courts. It promotes submissions and arguments about costs where the starting position we submit should be clear as a matter of principle. And lastly, on statutory review and service, one outcome of the Court of Appeal judgment is that it creates a disincentive for claimants to serve parties with an interest. No dispute that they're not required to do so under the rules. Individual claimants, that is. That, my lord, is not a dark hint. It's not meant to be a dark hint, as Lord Justice Golson suggested. It's a statement of practical reality. And we say it's a consequence of the fact that Practice Direction 8C, which reflects CPR Part 54, was not intended to have the multiple party costs consequences at the permission stage that the respondent supports. So the practical consequences of the position as it stands following the Court of Appeal's judgment are problematic in my submission, and they do support both the case for this court intervening and saying something about it, and the interpretation that we say should be given to the case law and the effect of the rules on the application of Bolton. My lords, subject to me checking, and I might well have, there might well be some points I've missed or other points I want to say, and subject of course to any questions that your lordships have, those are my submissions. So perhaps if your lordships give me a moment for me to check first. I don't think I have anything else. I know there's a small delay, but nothing's come through that I'm urgently asked to add. So unless your lordships have any questions, those are my submissions.
Could I ask you just a couple of questions about the facts? The pre-action correspondence that we have is between your instructing solicitors and Maidstone Borough. Do I take it that's the extent of the pre-action correspondence?
Yes, I think the only thing to add to that is it was copied to Roxhill, the interested party. I was sent a copy of it.
And the other question I was going to ask is, looking at the material to do with the challenge, it seems that there were a number of grounds of challenge, some of which concern the basis of the council's assessment of need, and some of which were specific to the particular site. Is that right?
Yes, yes, that's correct. It certainly was just specific to the site, but also attacked the general approach.
Yeah, essentially, there were issues to do with landscape and impact on air quality and so forth concerning the site, and there were issues to do with the assessment of economic need to do which were of wider ambit concerning the local authorities' policies.
Yes, that's accurate and correct.
Thank you very much. Well, if there are no other questions, then thank you very much for your submissions, Mr. Westaway. I think we might take the opportunity to consider where we've got to, having heard your submissions. And if the members of the court can, let me see. I think what we want to do is not to leave the meeting, but to turn off our video feed in the meantime, and we can then go into a private meeting to discuss where we are. Ricci, having having briefly discussed Mr. Westaway's submission, we think we can ask you to focus your reply upon a particular point. It can be identified in paragraph 21 of the Court of Appeal judgment at electronic page 130. And you'll see there that Lord Justice Coulson says that rules 54.8 and 54.9 were novel because for the first time in JR cases, they required a defendant or interested party to incur costs in order to set out their response to the claim made. Now, it's the next sentence which is particularly significant. It is implicit that such parties who are being put to that time and expense were prima facie entitled to their costs of so doing. Indeed, that's recognized by 54.92. Now, the point that Mr. Westaway has made, if I can put it in my own words, is that a private party defending his private interests as an interested party is in a different position in judicial review proceedings from the public authority whose decision is being challenged. And the consequence of the difference between the position of the public authority on the one hand and the private interested party on the other is such that one can't equiparate them in the way that Lord Justice Coulson did in that passage and say that both of them are implicitly, under the rules, entitled to the cost of filing the acknowledgement of service. So I'll be corrected by my colleagues if I haven't put the point quite aptly, but I think that's the point that we would like you to respond on. But we can leave that until 2 o'clock. We'll adjourn until 2 o'clock.
Thank you, my lords.